All right, appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, requesting the judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
But it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
We don't do judicial bias. I just have a statement straight to me telling you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge King Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Constitution against me this entire time. No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
All right, guys, here we go. The courtroom is already tense before anyone even raises their voice. The judge calmly asks for appearances, invites everyone to sit, and immediately turns to Mr. Crucell, who has filed what feels like a mountain of motions. But instead of clarity, confusion floods the room. The judge asks a simple question: which motion do you want to address first? And right away, the interruptions begin. The judge tries to narrow it down. What's new in this filing compared to the last one? Instead of a direct answer, Mr. Crucell spirals into accusations about bias and due process violations. That's when the tone shifts. The judge makes it crystal clear: if you don't answer questions directly, this is going to be a very long day. And trust me, it absolutely is.
All right, so now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making...
What statement is that?
It was
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside than what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
My objections on the record to make my case. So you're
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me, because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately.
Now listen carefully. The judge isn't playing games. He asks again, is this motion different from the last one? Instead of a yes or no, Crusail launches into claims about being ignored, about constitutional violations, about secretaries of state. And boom, the first warning lands. Interrupt again, and it's contempt. One more word, and it's a fine. Keep pushing, and jail is on the table. The judge explains something painfully basic. Agreeing with the prosecutor does not mean collusion. It's entirely possible the defendant is simply wrong. But Crusail refuses to accept that reality. The judge presses him, if I rule for one side, does that automatically mean I'm colluding against the other? Yes or no? When the answer won't come, the fines start stacking. $100. Then $200. And we are barely getting started.
Your Honor, again, you're trying to spin this here.
I'm not spinning.
My objection is based on you not allowing me to do it. And that's when you told me my objection to be.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once permitted on the why it's on the prosecutor to prove those things. There's the false words and irregularities.
All right. Let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You need to keep sure.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that?
You're fair.
I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting to all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'd like to put on the record that if whatever you would like to do from there, you can, because I won't until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Speaker, please arrested Mr. Crusail while he was in Huron Township. The Beaufort District Court has jurisdiction over offenses that occur within the township, both civil and criminal. This is criminal and civil.
Did you appeal Judge Green's decision on that motion?
I'm in the process of getting it because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to,
The judge can't just come in here and say that there's,
All right, now the real lecture begins. The judge lays it out with zero sugarcoating. Judges, by definition, must rule for one side or the other. That's literally the job. You don't get to scream collusion every time a ruling doesn't go your way. If you don't like it, you appeal. That's how the system works. But Crusail keeps insisting the court is aligning against him. The judge fires back, I'm aligning with the law as I interpret it. Period. And then comes the warning every pro se defendant hates to hear. You can't just disagree and keep arguing. You don't get unlimited retries. The courtroom is not a debate club. The judge reminds him, I tried to save you the first time you were here. But today? Today we're moving forward.
the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
all she said was that Judge Martin was sending aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they were submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine, then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons that I'm saying there's.
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my, dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper at the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge. Not because I don't like Mr. Crusail. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So, that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, the thing is, what
Mr. Purcell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or
Now things get aggressive. The judge shuts down the misuse of the word objection. This is not social media. This is not vibes-based law. If you object, you need a legal foundation. Not feelings. Not frustration. Legal grounds. The judge even gives him a simple example. If evidence lacks foundation, that's a proper objection. But yelling "I object" because you don't like a ruling? That means nothing. And here's the brutal truth bomb. You've never been to law school. You've never tried a case. You don't know the rules of evidence. That's not an insult, that's reality. And reality in a courtroom is unforgiving. Meanwhile, 2 contempt fines are already on the record, and the jury hasn't even been seated yet. This is spiraling fast.
do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
essentially, yeah.
Okay.
Prosecutors.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent, motion for judicial notice. What does that, judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cassell.
Then comes the jurisdiction argument. The judge breaks it down like he's explaining it to a stubborn teenager. The incident happened in the township. The township issued the citation. This district court has jurisdiction. End of story. A previous judge already ruled on that exact motion. It wasn't appealed. And guess what? You don't get to relitigate it in front of a different judge hoping for a different answer. That's not how this works. The judge denies it, again, and calmly tells him, appeal me if you want. But we're moving forward. You can almost feel the frustration building. The defendant wants to re-argue everything from scratch. The judge wants to start trial. And only one of them controls the courtroom.
No, Mr. Cassell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the 4th or 5th time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's why they should have tried and emergency stop the motion to stop this.
I already ruled on that.
Certain back acknowledge my motions for my extravagant. Nothing to do.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right? I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
Maybe I said, well, you just keep, each judge has done the same thing. They just keep setting it aside and acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my evidence.
What's your case that traveling doesn't mean operating?
I was having the fact that this court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
Stating an unlawful jury trial, and I think that blatant statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there's clear bias in this court against it.
Okay.
Violates my rights to a fair trial. 100%. And you want to keep overlooking. I know they make you seem like they're not a big deal, and
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, I just because I proved you on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it by Shank's man.
Now we hit the bias accusation. Motion to recuse for judicial misconduct. Denied. And the judge doesn't hesitate. You might not like how I talk to you. You might not like my tone. But that doesn't make me biased. In fact, he says something unexpected. I've been trying to save you from yourself. What should have been a minor civil issue has exploded into a full-blown disaster because of ego and misunderstanding. The judge makes it personal, but not cruel. He says he holds no ill will. He just won't allow irrelevant arguments to poison the jury. That's his job, gatekeeper of the courtroom. Efficient. Effective. Controlled. And whether the defendant likes it or not, the trial is happening.
It's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American Jurisprudence sites that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process we're kind of,
Which is not an appeal.
is an extreme, lawyer when there's bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be.
Next up, motion for relief from judgment. And here's where it gets almost ironic. The judge asks him directly, "Do you really want me to grant this?" Because if I do, those defaults you fought to remove? They come back. Case closed against you. Is that what you want? The defendant hesitates. The judge pushes for a yes or no. Silence. Confusion. And finally, the judge denies it. Then comes the notice of constitutional rights. The judge responds almost sarcastically, so am I standing on the Constitution? Filing paperwork to say you don't consent doesn't magically halt proceedings. The court doesn't require your emotional approval to function. And the message becomes clear. Symbolic filings don't override statutory authority.